Hey guys, happy Saturday. I am not trying to be a diva. As some of you know, I scratched my cornea yesterday like a fucking moron, and I spent a couple of hours in the morning at a eye doctor, which cost me hundreds of dollars. But I did get medicine, but my eye is extremely light sensitive. And I ended up spending pretty much the entire day in my hotel room yesterday after the eye doctor and picking up the medicine because I'm a fucking moron. But I did get the house that I was trying to get, so I'm very excited. We move in July 1st. And a couple of things that I want to go over tonight. It's actually kind of new. And again, I'm a loser for not realizing this sooner when other people have asked me. But I'm going to go through it tonight because I actually found an article on it and I was like, duh, I should have known this. But one thing I want to talk about first is, I don't know how many of you checked out Casey's video, her latest video, but you should. And it's pretty interesting because the reason why I'm telling you to check it out is I'm wondering if anybody else thought the way I did, and that was that it was intentional. And what I mean by that, I'll give you a quick synopsis, is Remaker and Detective Paskey, something like that. Paskey's husband was delivering pizza to a sequestered jury, and what should have been a mistrial for Brendan turned out that it wasn't, and she got like 1 day reprimand. But my thought was, and tell me if you guys agree or disagree, is that was the intention. They were trying to get a mistrial. They were because this whole case wasn't about Brendan. It was about Stephen. By the time Brendan's trial came to pass, Stephen was already in jail. He was already convicted. They didn't even need Brendan anymore. But you couldn't turn around and say, well, okay, we'll just, throw everything we have out on Brendan because then Stephen would have won on appeal. And you couldn't just say, okay, well, we're done with him. It doesn't work like that. They had to go through with it. Like I said in the last video, once you start, you couldn't stop. So in my opinion, maybe they were trying to get a mistrial because they didn't need him, but they couldn't just let him get off. So watch the video. Tell me what you guys think. I mean, am I the only one that thinks like that? I don't know. Maybe I am. Who knows? But some of the new stuff that I want to go over, a lot of people have asked me over recent months about why they didn't get new trials and why the Supreme Court and everything else. And, a lot of the talk has been, well, they didn't get a mistrial because, not a mistrial. They didn't get a new trial because, it's a big cult and it's an underground conspiracy. But really, it didn't meet the standard. And that standard is called the Strickland standard, and it was set up by a Florida case in 1984. Now, this could get a little boring because I'm going to read the criteria, and I really don't know how to make it exciting because I don't have it memorized. Nor do I feel like memorizing it, so follow along. But it was, like I said, it was a Florida case, but a guy really didn't have a criminal record, and he claimed that it was ineffective counsel, and it became the benchmark for what ineffective counsel actually is. And here's the standard, that to counsel rendering reasonably effective assistance given the totality of the circumstances, after outlining standards for judging whether a defense counsel fulfilled the duty to investigate non-statutory mitigating circumstances and whether counsel's errors were sufficiently prejudicial to justify reversal, the Court of Appeals remanded the case for application of the standards. So you have to think to yourself, okay, so what exactly are those standards? Here you go. Those standards are that, wrong page. Bear with me. It's been a long day. Okay. The Sixth Amendment right, which is the right to counsel. Sixth Amendment right to counsel is the right to effective assistance of counsel, and the benchmark of judging any claim ineffectiveness must be whether counsel's conduct was so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. The same principle applies to a capital sentencing proceeding, such as the one provided by Florida law, that is sufficiently like a trial in its adversarial format and is the existence of standards for decision that counsel's role in the proceeding is comparable to counsel's role at trial. Now, think about that, though, that if you really sit back and think, Kaczynski really wasn't ineffective counsel. We know it's ineffective counsel because we saw the after effect. We know it's ineffective counsel because of everything that he did and shouldn't have done, and all the shit he did with O'Kelly. But the Supreme Court doesn't see that because they only see what actually went on at trial. They don't see the backlash of it. So a convicted defendant's claim that counsel's assistance was so defective as to require reversal of a conviction or setting aside a death sentence requires that the defendant show that the counsel's performance was deficient, and second, that the deficient performance prejudiced the defense so as to deprive the defendant of a fair trial. Technically speaking, Brendan got a fair trial. Brendan went to jail due to his own statement, his own confession. Whether that confession was false or not has nothing to do with a fair trial. That's all stated after the fact. Now, the proper standard for judging attorney performance is that of reasonably effective assistance, considering all the circumstances. When a convicted defendant complains of the ineffectiveness of counsel's assistant, the defendant must show that the counsel's representation fell below an objective standard of reasonableness. Judicial scrutiny of counsel's performance must be highly differential, and a fair assessment of attorney performance requires that every effort be made to eliminate the distorting effects of hindsight, to reconstruct the circumstances of counsel's challenged conduct, and to evaluate the conduct from counsel's perspective at the time. A court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. These standards require no special amplification in order to define counsel's duty to investigate, the duty at issue in the case. Second half of that is with regard to the required showing of prejudice, the proper standard requires the defendant to show that there is a reasonable probability that, but for the counsel's unprofessional errors, the result of the proceeding would have been different. Now, thinking of the case, I don't think it would have been any different. I mean, Kaczynski may not have got a promotion, but I really think the outcome would have been the same based on his own testimony and his own confession. A reasonable probability is a probability sufficient to undermine confidence in the outcome. A court hearing an ineffective claim must consider the totality of the evidence before the judge or jury. And then the final part of it is, missed that again. This is so hard with my eye, but I'm doing it because it's my last night. The facts of the case, I missed one. A number of practical circumstances are important for the application of the standards set forth above. The standards do not establish mechanical rules. The ultimate focus of inquiry must be on the fundamental fairness of the proceeding whose result is being challenged. A court need not first determine whether counsel's performance was deficient when examining the prejudice suffered by the suffered prejudice. That course shall be followed. The principle governing ineffective claims apply in federal collateral proceedings as they do on direct appeal in or motions of a new trial. And in federal habeas challenge to a state criminal judgment, a state court conclusion that counsel rendered effective assistance is not a finding of fact binding on the federal court to the extent stated by U.S. Law 2254, but is a mixed question of law and fact. The facts of this case make it clear that counsel's conduct at and before respondent's sentencing proceeding cannot be found unreasonable under the above standards. They also make it clear that even assuming counsel's conduct was unreasonable, respondent suffered insufficient prejudice to warrant setting aside his death sentence. To me, folks, that's exactly what happened to Brendan. Is that even though on the outside, let me put my phone down, but even on the outside that it looks like it was so horrible and Kaczynski was so bad, the reason why he didn't get a new trial from the appeal court or Stephen or anything is because even if you take out Kaczynski, Brendan was still going down due to his own confession. And in my opinion, whatever it means, as far as my opinion goes, take it or leave it, doesn't really matter. That's why he did not get a new trial based on that. And I think it's going to be the hardest thing for his attorneys to get him a new trial based on ineffective counsel. Because honestly, again, and I did know this, due to the Strickland standard, you need to have, like, Kaczynski do what he did or have Brendan stand up. And this is where our justice system kind of fails in many ways, because Brendan's not smart enough to stand up for his rights. Because, I mean, we saw that when Barbara had recommended that he get rid of Kaczynski to begin with, Brendan froze. And that's a lot of people. You know, it's not just Brendan. That's a lot of people in jail. So speaking of people in jail, I also am working on something with DK Sale about a case in Tennessee. I don't have all the facts, so I would have brought it to you tonight, but it's very similar to a situation like Brendan, where he's just not smart enough to know. And DK had asked me to look into it today. It's a story, a book or a movie he's been working on for about a year now. So it's good stuff coming up. So I just want to throw that out there. But, you know, the reason why I even threw that out there, because it's true. You know, there's so many people in prison that don't do what they're supposed to do. They're not, they're not smart enough, or, you know, law smart enough, or whatever way you want to put it, to do the right thing. And it's really hurting a lot of people in jail. So that's all I have for you guys tonight. I'm glad that I was able to bring you guys something new, because, I mean, everybody's tired of the same old shit already. So check out Casey's video, though. Let me know what you guys think. Again, I think that it's possible that it was intentional and that they were trying to get a mistrial. So that's all I have for you guys. Have a wonderful night. And check out my other videos. Check out DK Sale. Check out Casey's video. Check out the website, even though I haven't updated them forever. And I will speak to you guys on Monday after my 15-hour ride home tomorrow. But it has been wonderful with no children, nobody, just me and the little furry Murray. And that's it. I'm looking forward to my move. All right. So have a wonderful night. Again, check out my other videos. Make sure you subscribe. Tell your friends to subscribe. We need everyone to subscribe. All right. Have a great night. Peace.